Dato', your book is here.
See you soon.
Ladies and gentlemen, welcome to the book launch of Law, Practice and Procedure of Arbitration in India by Dato' Professor Sundra Raju. We are so delighted you are able to join us this evening for the book launch, followed by a panel discussion on the evolution and future of international arbitration in India. My name is Irene and I'll be your host today. The event is jointly organized by the Asian Institute of Alternative Dispute Resolution and Thomson Reuters India. We will be hosting a networking session after the webinar today, so please do stay back, proceed to the Zoom meeting. The details will be available in your chat box. But for now, to start off, we would like to invite Mr. Gauri Shankar Nadesan of New Gen Knowledge Works to deliver an opening speech. So ladies and gentlemen, let us welcome Mr. Gauri Shankar.
I guess I'm audible, right? Okay.
Yeah,
yeah, okay, thanks. Honorable Mr. Justice A.K. Sikri, Honorable Judge retired of the Supreme Court of India, Mr. Darius Kanwata, Senior Counsel, Mr. Chakrapani Mishra, Partner Khaitan and Company, Dr. Stephen Wilske, Partner Glaze Lutz, Gaurav Pachananda, Senior Advocate, Shravan Unnam, Head of the Hyderabad Arbitration Center, members of the editorial board, our esteemed author, Dato' Professor Sundra Raju, all the dignitaries, members of the legal fraternity, media and press, ladies and gentlemen, a very good evening. It is my privilege to welcome this august gathering today for the release of the book, Law, Practice and Procedure of Arbitration in India. At the outset, I would like to talk about the journey we've had with Dato' Professor Sundra Raju. He has been an author for our Malaysian entity as well, and I got introduced to him through our Malaysian office. The first thing that struck me at that time was the boundless energy that he brought to a discussion. This is a rare passion that you see in people. My team and I have worked with Dato' Professor Sundra Raju for some time now on the book, and I've never seen this energy flagging across the journey. Sir, it's been a pleasure to work with you, and we are indeed happy to see the result of all the work put in by you, your editorial team, and my team in the book, Law, Practice and Procedure in India, being launched today. I would like to add a special word of appreciation to my team at New Gen Knowledge Works for working hard behind the scenes at the copy editing, typesetting, printing, and marketing of the book to meet schedules, and importantly, your expectations as an author. Honorable Mr. Justice A.K. Sikri, retired Judge, Supreme Court of India, has consented to release the book today and deliver the keynote address, and I wholeheartedly welcome him. I am not going to go into detail about the book, as I'm sure the different speakers during this event will be doing so. Without a doubt, it is a great new resource for the Indian and international arbitration community, as it provides a detailed practical guide on the Indian arbitration landscape. The book provides an in-depth analysis and prognosis of the evolving arbitral regime in India, detailing the latest legal precedents. Dato' Sundra's academic knowledge, his experience as a lawyer, construction professional, and as an international arbitrator can be seen through the book. A few words about us as a publisher. Thomson Reuters, a leading publisher in the legal space, works exclusively with New Gen Knowledge Works as its contracting affiliate in India and Malaysia. Together, we offer a varied catalog in the print and digital space with various commentaries and monographs across different practice areas of law. Based in Chennai, New Gen has been a leading presence in the publishing space, catering to various international publishers of repute across the globe for over 2 decades. We specialize in legal publishing, developing proprietary technology solutions, as well as managing the editorial design, manufacturing, and distribution of print and online publications. This book, Law, Practice, and Procedure of Arbitration in India, has been of particular interest to us at Thomson Reuters. During our pre-launch marketing, we have seen that the book has received good feedback from the market, and I'm sure the book will do very well. Once again, I would like to thank Dr. Professor Sundaraju, his editorial team, and our editorial production team for the excellent teamwork in bringing this production to the market successfully. With these words, I once again welcome everyone to this book release function. Thank you.
Thank you so much, Mr. Garishankar. I would now like to invite Mr. Pratik Singhvi to represent the Senior Editorial Board of the book Law, Practice and Procedure of Arbitration in India to deliver a speech. Mr. Pratik.
Good evening, everyone. First of all, my apologies that I've had to join from my phone because of a technical glitch, which tends to happen at the most important moments. Good evening again. My name is Pratik Singhvi, and I will be speaking on behalf of the Senior Editorial Board today. Before I begin, I would like to thank our keynote speaker, Justice Sikri, the moderator of the panel discussion, Mr. Sundaresan, the panelists, Mr. Khambata, Mr. Mishra, Dr. Wilsk, Mr. Panchanda, and Mr. Onam, as well as all the attendees for taking time out on a Friday evening to engage with us at this virtual book launch. I look forward to networking with all of you at the end of the launch event. I would also like to thank Professor Raju for envisioning the commentary, Thomson Reuters and Newgen for making the commentary a physical reality, the Asian Institute of Alternate Dispute Resolution and all its members for organizing the book launch, the Hyderabad Arbitration Center and the Covis Foundation Conflict Resolution International for supporting the event. It is truly a privilege to be a part of and speak on behalf of the Senior Editorial Board today. The Senior Editorial Board comprises of 13 individuals. I would first like to list out the members of the Senior Editorial Board, and you may recognize them on the screen before you. They are Anushka Shah, Pritika Malhotra, Rohan Deshpande, Sarthak Malhotra, Ashna Agarwal, Astha Chawla, Astha Singh, Geetanjali Murthy, Vishal Agarwal, Mahi Mehta, Puneet Ganapati, Mohit Mahala, and I, Pratik Singhvi. It would be remiss of me to not tell the audience that these 12 individuals that I worked with are amongst the most talented, knowledgeable, resourceful, and dedicated people I've come across. You can also read more about each member of the Senior Editorial Board at the start of the commentary. Moving on, I'm confident that I have the backing of the entire Senior Board when I thank Professor Raju for making us a part of his project and providing us with an experience of a lifetime in exchange for some sleepless nights. I'd say that it's a fair trade-off. With the remaining time allocated to me, I would just like to shed some light on how the Senior Editorial Board approached drafting of each chapter, and then segue into the purpose of the book. I will first start with the approach. So before we began writing, the first question that Professor Raju asked us was what kind of a book did we want this to be? And the unanimous answer was that we wanted this to be a legal and a practical guide or a handbook of sorts for arbitration law in India. One that we could use to answer everyday issues that arise before courts and tribunals. Once we got cracking, the process we followed was that one of the members of the editorial boards would draft the first cut. Then the chapter would rigorously be reviewed, supplemented, and revised by at least 3 members of the editorial boards. After which Professor Raju personally reviewed and settled each of the 51 chapters. Once the manuscript was complete, all of the 1500 odd pages went through at least 2 rounds of proofreading. The idea was to be thorough and perfect the manuscript in a way that benefits the reader. In terms of the resources that we used, of course, there was research, there was brainstorming sessions, there were standard templates, and these were our natural go-to options. But in addition to that, we reached out to several practitioners with many years of experience to shed light on everyday issues. The idea was to harmonize the law with its practice. And here I must add that Professor Raju's practical inputs were absolutely invaluable. With this, I would like to segue into the last bit of what I would like to touch upon, which is what is the purpose behind another commentary on arbitration in India. And the purpose for us was to canvass the law, the practice, and the procedure of every aspect of arbitration in India and compare it with positions in civil and common law countries. Given the experience of Professor Raju and the editorial boards, we managed to address issues that arise out of both domestic as well as international arbitrations through the lens of everyday practice. We hope that this commentary proves to be a practical handbook every time a reader picks it up. And finally, I would like to end by saying that all of us on the editorial board hope that you enjoy reading the commentary as much as we enjoy drafting it. And we hope to connect with each of you in person as well as virtually in the future and take the conversation forward on the evolving arbitration laws in India and around the world. Thank you and have a pleasant evening.
Thank you, Mr. Pratik, for that insightful speech. I would now like to invite Ms. Ridhima Sharma to represent the junior editorial board of the book Law, Practice and Procedure of Arbitration in India to say a few words. Let's welcome her.
Greetings, everyone. I'm honored to have this opportunity to speak with all of you today on Datuk's new treatise, Law, Practice and Procedure of Arbitration in India. The landscape of arbitration in India has undergone an extensive reforms in recent times, particularly pursuant to the 2015 amendments. The law has evolved extensively to complement the needs of India's globalizing economy. We have come a long way since the decision of the Supreme Court in Balco in 2012, delineating the contours of judicial intervention to the decision in PASL versus GE Power in 2021, allowing Indian parties to choose a foreign seat. The legislature has given effect to certain amendments to bring the law in tandem with the global practices, and the Indian courts have also rendered a catena of pro-arbitration decisions over the last decade to make India an arbitration-friendly seat. Now, I will talk about the book. Datuk has wisely articulated the book subject-wise rather than giving a section-wise summary, which I feel is one of the most unique features of this book. And this was one of the first instructions which were given to us, that the book is not going to be a mere reiteration of the law as given by the courts, but it has to have certain practical aspects to it, so that even if a law student picks it up or an experienced professional picks it up, it gives the same explanation, the same sense of understanding to that individual. One of the most unique features about this book is that it does not only give a snapshot of the domestic approach to the concepts in the Indian Arbitration Act, but it also includes various international jurisdiction practices for comparison to help one understand the practices better and in comparison with the global practices followed across the globe. While the treatise explains debatable issues pertaining to Arbitration Act with supreme clarity while delineating all the decisions, it also touches upon the various practical nuances and the nitty-gritties of the arbitration law in India. Initially, when I heard that Datuk is looking for a junior editor team member for his new book, I sent in my resume instantly to him. As working with an authority in the field was one of the best things that could have happened with a budding lawyer like me. I was in my 5th year of law school at that point of time. Datuk always took time to help us understand the concepts better and provide us with the junior editors with whatever resources we needed to analyze various concepts and to understand them better. Learning under the guidance of Datuk and with the help of the senior editorial board, I was able to absorb a mass of knowledge and experience that is helping us in our professional lives as a lawyer. I would like to thank everyone involved in the writing of this book. I had an amazing time working with everyone, the junior editorial board, the senior editorial board, and most of all, guidance of Datuk has helped us to come up with the treaties in such a beautiful manner.
Thank you, Ms. Redeemer. Ladies and gentlemen, it is with great joy I now invite Datuk Professor Sundra Raju, author of the book Law, Practice and Procedure of Arbitration in India, to deliver his speech. But as a brief introduction, Datuk Professor Sundra Raju is the founding president of the Asian Institute of Alternative Dispute Resolution. After obtaining his first honors degree in housing, building and planning from University Science Malaysia, Penang in 1979, he started working with the Central Bank of Malaysia, then proceeded to Australia and obtained 2 professional degrees in architecture and town planning. Datuk Sundra is an advocate and solicitor of the High Court of Malaya. He's also a professional architect and registered town planner, with numerous appointments as arbitrator, either as chairman, co-arbitrator of 3-man panels, and sole arbitrator in international and domestic arbitrations. Thus, Datuk Professor Sundra Raju has authored, co-authored, and edited, contributed over 12 book publications since 1998 in the area of arbitration, contract, and construction law. So ladies and gentlemen, without further ado, let us put our virtual hands together as we welcome Datuk Professor Sundra Raju.
Thank you, Irene. Excellencies, distinguished luminaries who contributed a foreword to the book, Mr. Gauri Shankar and other colleagues from Thomson Reuters, India, members of the senior and junior editorial board, whom I respect a lot, distinguished moderator and panelists, ladies and gentlemen, a very good evening. I thank the joint organizers, the Asian Institute of Alternative Dispute Resolution and Thomson Reuters India, for this launch of the Law, Practice and Procedure of Arbitration in India book, and the subsequent panel discussion on the evolution and future of international arbitration in India. I also thank the supporting organizations, Hyderabad Arbitration Center and Covis Foundation Conflict Resolution International, for their endorsement of this event. I'm privileged that all of you all are attending this event, albeit remotely. This is now the new norm. I express my utmost gratitude for the kindness of the luminaries who have contributed wonderful forwards for this book, namely Honorable Justice Arjan Kumar Sikri, who is present here, together with Professor Anthony Lavers and Mr. Chan Ling San, SC. I'm also appreciative of His Excellency Professor Dr. Kennedy Gaston, Right Honorable Chief Justice Tun Zaki Azmi, and Dr. H.C. Roth A. Schutzel for writing such insightful forwards. Thank you so much, Honorable Justice Sikri, for agreeing to deliver the keynote address and also launch this book. I commend to you all, and you can see why I do it with great pride, the junior and senior editorial board of the members of this book. Without them, this book cannot be done. And it is very much part of their work. For the senior editorial board, they are Anushka, I think Prateep, Pritika, Rohan, Satak, Ashna, Asta, Gitanjali, Vishal, Mahi, Punit, and Mohit. And the junior board is Rithima, Katuyun, Mishtan, and Pat. My greatest acknowledgement is in the dedication of the book, namely to my late parents, Mr. and Mr. Nadaraja and Madam Lakshmi, who gave me life, my family whose unconditional love through thick and thin is priceless, Datuk Mahadev Shankar, a great Malaysian judge and doyen of the Malaysian Bar, and finally the late Professor Ray Turner, who was my teacher and mentor, and subsequently like father and friend. Ladies and gentlemen, the journey to write this book started with my first Law, Practice and Procedure of Arbitration in Malaysia, published in 2003 by LexisNexis. The second edition was published in 2016. And when I was the director of the Asian International Arbitration Center, then at that time known as the Kuala Lumpur Regional Center for Arbitration. This second edition in 2016 was well received both in Malaysia and around the world. It was used as promotional material to showcase the Malaysian arbitration regime. Honorable Justice Sikri, in his foreword to this book, states that he is intrigued as to what prompted me to write this book, Law, Practice and Procedure of Arbitration in India. I can understand why he is puzzled. I am not Indian, but a Malaysian. I'm not schooled in Indian law, not practicing in India. And also it is universally accepted that it is difficult to master Indian law, as India, being one of the world's great common law jurisdiction, has great diversity, continual legislative change with an active and learned judiciary issuing detailed and extensive judgments in various areas of the law. This book was conceived and born out of adversity. In November 2018, at the height of my tenure as director of the Asian International Arbitration Center and as deputy chairman of FIFA Adjudicatory Chamber, my entire world came tumbling down with catastrophic effect. It may be partly motivated by envy, professional jealousy, part of a job grab and take over the center, the event and actions by the former Malaysian Attorney General and his installed ally, the acting director of AIAC and others, totally degraded my work at the center from 2010 to 2018. Based on an anonymous letter, AIAC, despite being an international organization, was raided. I was arrested, forced to resign, then criminally charged that the purchase of the law, practice and procedure of arbitration in Malaysia book by the center was for my personal benefit. This was despite the intervention by the Asian African Legal Consultative Organization, ALCO, who had supervision and dominion over AIAC and its funds. ALCO clarified that it was aware and had approved the purchase of the books for the said promotional activities and communicated the same to the Malaysian authorities. It also confirmed that I had donated the royalties received on the book back to the center. Unfortunately, it was ignored. The actions continued. It was left for the courts to decide. I was resoundingly vindicated by the Malaysian magistrate, high and federal courts, who held the authorities had acted illegally and went on to squash the charges, and I was freed. The courts held that the Attorney General's absolute discretion and powers to prosecute is subject to judicial review in rare and appropriate cases. The law changed in Malaysia. The criminal legal process, which started in November 2018, ended in April 2021. On 1st July 2021, ALCO followed up with the judgments requesting the then Malaysian Minister in charge of law and the current Malaysian Attorney General that I either be reinstated to the position of Director of AIAC or be compensated. Thus far, ALCO's request has been ignored. In the meanwhile, a vendetta was launched starting in November 2018, focused on erasing and continual expropriation of my contributions to ADR in Malaysia and the world. It would seem that the personal pride of individuals who wish to assert their superiority over others had continued to triumph. It is an experience I will not wish on anyone else. It is still difficult for me to understand why these tragic events occurred. What really motivated it? My sadness arises mainly from the terrible betrayals and treachery. The vehemence of the continual vendetta has been quite extraordinary. It remains a surprise for me. Given the situation in early 2019, I was quite free to take up new assignments with very little coming from Malaysia. I had in January 2019 just completed a 931-page definitive book with Dr. Thomas Kudzel on the Malaysian Arbitration Act amended 2011 and 2018 and the AIAC Arbitration Rules 2018 published by Sweet and Maxwell. It was overshadowed by the negative publicity affecting the Malaysian arbitration regime and AIAC. In 2019, I then decided to apply myself in figurative exile on creating an arbitration book not based on Malaysia. Having successfully analyzed and captured the arbitration regime in Malaysia, I felt equipped to undertake a similar exercise in other Asian jurisdictions with developing arbitral regimes. It was to help set out a roadmap for Asian arbitration. It was also part of my longer-term contribution and ambition to support Asian and African jurisdictions wanting to make themselves attractive as a safe seat and a hub to retain their own arbitrations and attract arbitrations from outside. All this would lead to a better investment, trading, commercially viable ecosystem, bringing prosperity and gain for the heartland. India seemed a natural choice, just like China had always been near to my heart. My ancestors from my father's side came from Tamil Nadu, India to Malaysia in the 19th century, where migration was the norm in search of a better life, and also contributed to nation building in our new homeland. My mother was ethnically Chinese, but culturally Indian. My siblings and I spoke Tamil at home, particularly with our parents. As Malaysian Indians, we shared a common culture, but owed our loyalty to Malaysia. Also, I have been following legal developments in India. In recent years, especially with the enactment of the Arbitration and Conciliation Amendment Act 2015, Indian courts have started to aligning themselves with the global pro-enforcement approach and philosophy. India, as a country where majority of arbitrations were ad hoc, suddenly started making efforts to legislatively recognize and encourage institutional arbitrations. There was a tremendous interest in arbitration in India, with weighty learned tomes written with gravitas. On analyzing them, I realized that most Indian books were detailed commentaries with a section-by-section approach to analyzing the act and the law. This presented an opportunity to me. I wish to develop a more holistic practice guide which would focus on the practical and procedural aspects of arbitration in the country and would serve as useful guidance for arbitration practitioners. Thus, my journey continued. Although the book was initially intended to be focused on India, during the process of developing ideas and structuring chapters, I decided to alter my approach and instead blend the global international arbitration practice into the text and contrast and compare it with the Indian position. Finally, after I started work on the manuscript in early 2020 and completed in 2021, I leave it to the users to decide whether the book achieves my objective. It would serve as a one-stop text for readers and practitioners, giving them a holistic insight on the Indian arbitration practice compared and contrast with the international scenario. Ladies and gentlemen, this book also aims to provide a practical guide to arbitration practitioners, in-house counsels, judges, institutions, both in India and abroad, to expand their knowledge on the law, practice, and procedure of arbitration in India, literally reflecting the title of the book. I have sought to explain and set out the best practices for conducting arbitration in India. My task was made more interesting due to the purposive legislative changes made on a regular basis and a number of landmark judgments progressing the use of arbitration as alternative dispute resolution mechanism. For example, in the midst of working on the manuscript, I had to incorporate amendments made to the statute by the Arbitration and Conciliation Amendment Act 2020. I remember Rohan actually bringing this to my attention with Pratik. And then the senior editorial team assisted me in reviewing and redoing previously finalized chapters to follow the new legislative position. We also had to incorporate important new rulings issued by the Supreme Court. In view of facilitating every reader, this book is not structured, as Rihitma pointed out, as per sections of the Arbitration Act, but instead as topic by topic perusal of the essential procedures under the Indian arbitration regime. This approach, in my opinion, provides a complete picture of the law, practice, and procedure of arbitration in India, moving beyond the contents of the Arbitration Act. Beyond adopting such an approach has enabled me to clearly show the interplay of the Arbitration Act with the rules of the major arbitral institutions in India, as well as other arbitral institutions around the world and the New York Convention. The debts I owe for this book are enormous. As always, I've received help from various persons and record my thanks. I'm extremely grateful to my two editorial boards, and you can see how clever they are. comprising of young practitioners and students in the field of international arbitration. It was indeed a delight to work with each one of them who assisted and contributed, and we learned from each other in the process. I thoroughly enjoyed the journey of being familiarizing myself with the Indian arbitration space through these bright young minds, often through valuable discourses and writing them into the text. I also thank my family for always being there for me. They are the bedrock of my existence. My gratitude extends to the editorial team at Thomson Reuters India Private Limited, especially Gauri Shankar, Girish Kamat, Srividya, Bhavana, Rachel, Dishka, Jamina, and Rajagopal for their editorial assistance and strong support required for a successful publication of this book. I thank my team at AIADR for their hard work for this event. I trust the law, practice, and procedure in arbitration will provide readers with an almost complete reference guide to answering important questions which arise during the course of practice of arbitration in India and perhaps elsewhere. Thus far, I have tried to make myself useful and also keep myself busy. However, I have become suspicious of achievement. Ultimately, everything like Ozymandias will crumble into dust. Thank you so much for your patience and for listening to me. Please keep safe and healthy. Thank you.
Thank you, Dato' Professor Sundar Raju. Now we are honored to invite the Honorable Justice A.K. Sikri to the platform. Justice Sikri has authored over 4,700 reported judgments in different fields of law. He was chosen as one of the 50 most influential persons in the world who impacted the growth of international intellectual property laws for the year 2007 by MIPA. He wrote scholarly articles in various journals and presented learned papers in various national and international conferences. He has several articles in the field of human rights, commercial laws, arbitration, and mediation. Currently, he's the International Justice of the Singapore International Commercial Court, SICC. So, ladies and gentlemen, it is with great honor. Let us welcome Justice A.K. Sikri to deliver the keynote speech.
Thank you, Erin. Good morning, good evening to everybody, depending upon the jurisdictions from which they are attending today's function. And Dr. Raju, who is the star of the day, with his editorial team, who have done tremendous work in helping Dr. Raju to produce this excellent work. Actually, what I was thinking, I had written that in my foreword as well, that I was pleasantly surprised when Dr. Raju requested me to write forward to this book. And I knew that he told me that there are 5 or 6 more persons who are also writing the forward. And as I said in that, that I'm little intrigued that he's writing about Indian arbitration law. So today, Dr. Raju, in his address, has solved that mystery. But in the process, I mean, today I'm really beholden, and my regard and my respect for him has increased multifold for the reasons, the determination and the grit with which he fought adversaries in his own country and the way he came out victorious. I mean, this is working in such adverse conditions and then trying to dislodge the public opinion which may have been falsely created because of such sinister moves. And thereafter, coming out of it with flying colors is I think it is an achievement in itself. So what I feel is, and the good thing is, that all this did not deter you from the path which you had taken in the arbitration law, in other related fields. You kept on doing that good work, and you have ultimately come out with this stupendous work here. Of course, Mr. Rajshekharan, in his inaugural, I would say, speech while introducing this, Mr. Rajshekharan from Thomson Reuters has mentioned about Dr. Raju, and has very rightly said about his rare passion of Dr. Raju, which has really helped him in produce this book. And I would say that I find today that Dr. Raju, you are a man with Midas touch. I think whatever you have touched, you have turned that into gold. And I had heard about your contribution and a very, very important contribution in turning around and bringing glory to the otherwise dormant KLRCA, and which, in fact, it is only then when I came in contact with you and I knew the way you were working in that field. I had then thereafter known about the various books on arbitration law and various articles you had written, Malaysian arbitration law, and all those have become success. So that therefore it shows your Midas touch, your masterly treatment of Indian law is very much visible in this book. I have, in fact, touched upon this aspect even in my foreword, and today both Pradeep Singhvi and Ridhima Sharma, they have touched upon it as to what is the focus of this book and why this book is written. You see, as far as Indian arbitration law is concerned, Dr. Raju, you are right that there are already many, many books. So therefore, when there are so many books written by Indian authors about Indian Arbitration Act, and some of those books are really doing well as well, they are the work is appreciated, no doubt about it, including by our Justice Indu Malhotra, who had written book on arbitration law. Then why another book on arbitration law? And Dr. Raju, as well as the two members of the editorial team, have clearly demonstrated that why this book was written. It is a totally different kind of treatment which is given to this book, which I have mentioned about this even in my foreword. What is important is that the topical, instead of section-wise commentary, as Dr. Raju says, but topic-wise discussion on each. And therefore, the fabric and edifice of the works of the author in the area of arbitration law in India stands out tall, I would say, for a variety of reasons. The published work is not a pure academic jargon, but eloquently stretched legal position and analyzes with crystal clear answers that are of tremendous assistance both to the bar and the bench, as well as other stakeholders in India and abroad, rather much more beyond the traditional borders. In a way, the jurisdiction of the book is extraterritorial in as much as, while dealing with Indian position in the field of arbitration law, it undertakes journey into comparative law. This becomes handy in dealing with complex issues of conflict of laws, which we come across almost daily while dealing with international arbitrations. Actually, we are in the era, in a era of globalization, and when the and arbitration law is one example in itself, that it is most of the countries have enacted this arbitration law based on UNCITRAL's model law. But interesting thing is, even when that is so, and various jurisdictions have their with little tweaking, and fundamentals remain the same, which UNCITRAL wanted, and all are incorporated. But the journey, judicial journey of interpretation and the way how the case law developed in each country is quite divergent, and this have gone in different ways. But ultimately, all this calls for an international approach, and what we should have on certain principles, the uniform methods. And therefore, the comparative analysis of the issues which arise in various jurisdictions that becomes important. And I think Dr. Raju's experience, not only in Malaysian law, but in international law of arbitration, came very, very handy, as I have observed while reading this book with the great interest. And the kind of solutions which he has provided in respect of each subject. And therefore, it is going to be, when we are in the area of convergence of laws, when economically and legally the legal word or legal system is shrinking. And I have seen that we're, as I said, that when we talk of a conflict of laws and certain issues which may be based on same provision taken from the model law, but still divergent approach which is given. So in this whole process, I would say that when you look at from this angle as well, this book stands out all. And that is one feature in this book that makes it unique. Because normally when you write about a particular law in that country, your focus would only be on that. But here, with that dexterity and craftsmanship, the touch which is given to this book, it is going to be a popular book, not only in India, but in other jurisdictions as well. And I must congratulate Dr. Raju, along with you, your two editorial teams. And if I give an example that in this victory, if you acted as I'm taking an example of from our mythology and giving that parallel. If you acted as Rama, the two teams were the Vanar Sena or Monkey Brigade, who helped you a lot. And without them, you could not have been a victorious person. So therefore, credit goes to each and everybody. And my congratulations to Dr. Raju and his team, and looking forward for many more such occasions. Thank you very much.
Thank you, Justice, the Honorable Justice A.K. Sikri. With that, ladies and gentlemen, we are proud to announce the launch of the book, Law, Practice and Procedure of Arbitration in India. Ladies and gentlemen, now we are pleased to feature the forward writers, author, senior editorial board, and junior editorial board of the book, Law, Practice and Procedure of Arbitration in India. Thank you once again to the Honorable Justice A.K. Sikri for launching the book, Law, Practice and Procedure of Arbitration in India. Ladies and gentlemen, we are now pleased to announce that Thomson Reuters India has prepared a special discount code for all our participants, especially here today. So the link will be in the chat box. The book is available for purchase online. If you put in the promo code SR20, you stand to enjoy a special discount of 20% off the book just for you today. Right now, we would like to take a photography session of the editorial board, forward writers, our friends from Thomson Reuters India, Mr. Gauri Shankar. So ladies and gentlemen, if you just give us a moment, to all our panelists here today, if you kindly on your video at the count of 3, our technical team will be taking a photo. Thank you so much for being patient with us. Thank you so much for turning on your videos. All right. So 1, 2, 3, give us a big smile. 1, 2, 3. 1, 2, 3. 1, 2, 3. All right. Thank you so much to all our guests and participants here today. Also, be reminded to stay until the end of the webinar for a special networking session on Zoom in another room. The link will be in the chat box, so you just save the link or you can click the link. It will lead you to another room. It is with great pleasure. I would now like to hand over the time to our panel moderated by Mr. Somaseka Sundaresan. We have a fantastic lineup of speakers today. I'm sure you are looking forward to a lot of insight. So without further ado, please welcome Mr. Somaseka Sundaresan to the platform to introduce our panel speakers and start our panel discussion.
Thank you, Irene. It's a pleasure. It's been my fortune to moderate a discussion with a panel like this. It was fascinating to hear Datuk Raju's story preceding the book. And when I was asked to moderate this panel, I asked for reading through a copy of the book. And I do think that as a person of Indian origin, if I may, Datuk Raju, it is fascinating to see the construct and the approach to the book. I didn't realize then that you were an architect, but I've tried to construct the architecture of this discussion somewhat on the lines of the book so that we could take up specific issues that would be put to the panel. The approach we'd adopt in this panel is that we're going to maximize the time for the panelists to express their views. I'd only be steering some of the discussion. While I'll invite some of you specifically to comment on something, please feel free to supplement, interject. Let's make this as lively as possible. And I think we have what, about 60 more minutes? Or yeah, okay. So let me begin by a very, very brief, quick introduction of the panelists. It's my pleasure to introduce my dear friend, Darius Kambata, who's a senior counsel. He's held public law offices of the Advocate General of Maharashtra and the Additional Solicitor General in Bombay. He's the member of one Essex court, and he's somebody who's been part of the Law Commission's draft amendments to the arbitration law in 2014-15. I'm honored to welcome Dr. Stephen Wilske, who's a polyglot, as I can see from his profile. He speaks multiple languages. He's a learned arbitrator in numerous arbitrations, national and international, on project-related disputes, M&A disputes, joint ventures, and also is a professor of long standing in multiple universities. I'm pleased to introduce Mr. Gaurav Pachnanda, who's a senior counsel for over 10 years. He used to be in a commercial law firm called P&A Law Offices and has moved on to be an ace litigator and an arbitrator. Again, contributes to the academic world. He's an adjunct professor in the Jindal Law School. I'm also honored to introduce Mr. Chakrapani Mishra, a leading disputes resolution professional, a partner in Khaitan and Company, a national law firm in India. He's himself an arbitrator, a mediator, and an expert witness in international arbitration on Indian law issues. Last but not the least, I welcome Mr. Shravan Unnam, who's set up the Hyderabad Arbitration Center. And we're going to talk a lot about institutional arbitration and the role it has to play in the evolution of arbitration in India. Mr. Unnam also is a commercial disputes lawyer in Hyderabad and has handled various arbitrations and mediations as a counsel. So may I begin this discussion by broadly inviting each of you panelists to very briefly speak about some of your thoughts and your, as an opening set of remarks, I'd like you to consider discussing the state of alternate dispute resolution in India. What achievements, if any, we've made in the past 25 years since the 1996 law? What have been the challenges? What have been the attempted solutions to these challenges? And what lies ahead? What are the challenges that further need to be dealt with? May I invite Darius to open and make his remarks?
Thank you, Som, for your very kind introduction. And I really want to start by saying that I share what Justice Sikri said. My admiration and respect for Datu Professor Sundaraju has really increased by leaps and bounds after hearing what he had to say. I was unaware of all this. I knew that Dr. Sundaraju was an eminent practitioner and he'd done a huge amount for arbitration internationally and was head of the center for several years. I remember hearing him make a very distinguished address at a conference in Penang several years ago. But I think he has gone through a trial by fire and has come out in blazing glory. And I reach out to him and I congratulate him. And I think he should be a role model for so many of us and so many of the younger bar to show why you must not accept injustices and you must fight and vindicate yourself. And congratulations to him. It mustn't have been easy. He seems to have done a Herculean thing by coming out with this book, going through each of the 51 chapters, as we were told. And I always welcome a book of this nature on Indian arbitration because it gives us practicing in India a perspective that perhaps we don't always share or look through when we practice in India. We see arbitration in India very much through an Indian prism or lens. And it's interesting to have an objective outsider look at arbitration and analyze it. I saw I haven't gone through the book, I confess, but I've seen the index and I understand it's a book for practitioners, which is also interesting because most books in India, distinguished as they are, don't have that particular angle to arbitration. The fact that there are so many books on Indian arbitration is itself a good sign. It means Indian arbitration is coming of age. And it's not been an easy journey, as you all know, and it won't be an easy journey in the future either. And that's part of the strength of the system in India. I always compare India to the tortoise in the famous fable of the tortoise and the hare. We generally are slower, but I think at the end of the day, we offer a surer path in terms of litigation, justice delivery, and indeed in economic investment and ventures. We are a very litigious people by nature, and our courts are extremely active and innovative. And that sometimes leads to interventions in arbitration, which are not always welcome. But these have always been well-intentioned. And there have been several blips and starts in the history of how arbitration has evolved in India. The 96 Act, as all of you know, came in again with a lot of hope. It went awry for a few years in terms of its implementation. But I think starting with the Balco judgment, with several other decisions of the Supreme Court, with the 2015 amendments, Indian arbitration is very much on the path of recognition of party autonomy, non-interference, enforceability of awards, including foreign awards. And every time we come across a matter which either we're appearing in or we hear about, it's heartening to note that most courts, and certainly the Supreme Court and all the leading high courts, have now become very pro-arbitration in their approach. There are myriad issues that arise. And sometimes one feels that just when we've gotten over one set of issues, another has risen up. But that, as I said, is part of a common law system. So I think, generally speaking, the journey will be a continuation. Minimum judicial interference in arbitration, particularly at the early stages, is still a goal. Easy enforceability and quick enforceability, and the latter I know is always difficult in a system which has a huge burden of litigation and arrears, not just commercial litigation, but writ law litigation, administrative law, service law matters. You must remember this is 1.2 billion people all going to courts for justice, and the justice delivery system is hampered by a lack of investment, often a lack of judges. So there are difficulties, but with all those difficulties, I believe our judges are coping, and they are turning out pro-arbitration judgments on a daily basis, because you're only generally the outside world looks at the Supreme Court. But we have very active arbitration courts in the Bombay High Court, in the Delhi High Court, in several other high courts, who are also on almost a daily basis getting the arbitration system into full flow. I think in the future, as I see it, we have most of the software in place in terms of the laws and the general trend of implementation, of course, barring a few aberrations. What we will need to do in the future now is to rejig the hardware. And by that, I mean the way in which we practice arbitration, both as counsel as well as arbitrators in India. That needs some overhauling. And the way we approach arbitration, even when we appear in courts in matters dealing with awards or arbitrations, again, the approach will have to change. I do believe it will, but that is an area which I think is going to take a little time, and that's where we should all be focusing on the future, in streamlining the way we practice arbitration, the ability to put everything into writing, to curtail long arguments, focus cross-examination, cogent, tight written submissions, no ambushing of the opponent. These are practices we must inculcate, and hopefully will inculcate in the years to come. And I am generally hopeful about the future of arbitration, and it's not going to be a pot of gold at the end of a rainbow. It's going to be a process, but I think it's an ongoing process, and it's an exciting process as well.
Thanks, Darius. May I now invite Stefan, who's promised a provocative opening set of remarks to set the tone for the discussion. Dr. Velski, you're on mute. It's fine.
Yes. Irene, are you directing my PowerPoint presentation? Yes. Okay, I'm very honored to be invited to this great event with so many celebrities of Indian arbitration law and practice. I'm simply afraid that you will regret having invited me, because my mission is, as already announced, to be a bit the agent provocateur. I'm sharing with you some perceptions of Indian arbitration law and practice from a foreign arbitration perspective, which might or might not reflect the current reality. And I confess I have not yet digested this very impressive book by Datuk Professor Sundra Raju with the 1,600 pages, it's even more. You could say, if you see my perceptions, they are all marked with a question mark, so I'm kind of cautious. You could say they are based on prejudices, they are outdated, they do not reflect reality, but these are perceptions which exist abroad, and you have to deal with them because they are kind of reality. When I met my wife for the first time, her prejudice was Germans like sauerkraut so much they eat sour cabbage about three times a day, and they even have sour cabbage juice. I mean, that was her perception, and it took some time to overcome that. Okay, next slide, please. So, I mean, the first perception is in India, I mean, my practice is, and I'm serving quite some time as a shadow counsel, meaning Indian arbitration practitioners are running the show, and I have to kind of translate, I mean, the thinking to the German client. It already starts with ad hoc arbitration, which I think has always been, I mean, the normal way to do it. My question was always, why ad hoc arbitration, which requires the necessary backup by state courts? And my question was always, did we not choose arbitration simply to avoid the intervention of the state courts for all kind of procedural questions? I'm well aware that institutional arbitration is not a no-go anymore in India. There are various initiatives, and I very much hope that at some point in the future, institutional arbitration will rather be the rule than the exception. The next issue, when I had my first arbitration and when it was about selection of arbitrators, I was only presented with a list of retired state court judges as arbitrators. Being well aware of the backlog of cases at the Supreme Court, at the High Courts, my question was, why only retired state court judges? Are they getting better or faster after retirement? Next provocation, please. Now, a question which I think is also important when you decide on the right arbitrator. This is the diversity of the arbitrator pool. And I'm wondering, is the elderly male arbitrator really always the right choice in arbitration, seated in India or dealing with Indian parties? This might be my ignorance, but I do not know a single active young female arbitrator. Again, I hope that you will all come up and say, this guy doesn't know anything. You can tell me at least 5 or 10 young female arbitrators, and I leave it up to you how you define young. The next provocation, please. Why does it take so long? I'm currently in an ad hoc arbitration with 3 retired judges, 2 former Supreme Court justices, 1 chief justice of a high court. It took now 12 years and the arbitration is not over yet. And many people believe, correctly or wrongly, arbitration is faster than state court proceedings. And there is sometimes really a disappointment when it comes to arbitration in India because it is dragging on. And then the last provocation, Indian law, Indian case law, always good for a surprise. And then let's start with the surprises from a non-Indian perspective. Next issue, please. Yeah, one permanent issue, we discussed it already today. The perception is always that Indian courts intervene in arbitrations seated abroad. I'm aware there's this old Bhatia decision, which has been overruled by Balco. But then once you think, okay, Bhatia is over, you are advised, I mean, for old dispute resolution clauses, it's still alive. So, I mean, the perception is when you sit in when you deal with an arbitration, with an Indian arbitration, they are always somehow the courts in the background. Next issue. Does India recognize and enforce all foreign arbitral awards made in the territory of New York Convention states? My understanding was always there are certain New York Convention states, over 123, if I'm not mistaken. If you go to India, you're advised that only those New York Convention states notified in the official gazette are considered to be New York Convention states, which comes as a surprise to a foreign practitioner. Another issue, I'm currently dealing with an arbitral award of only 80 pages and a minority decision of some 350 pages. And now the Indian colleagues are telling me the whole time, because both parties have gone to court, it's possible that a minority decision can become the majority decision. This is absolutely frightening for a non-Indian party who believed, okay, we can live with the majority decision, but there is this threat triggered by the Sangyong decision that all of a sudden the minority decision can become the majority decision. Whether right or wrong, this is kind of the perception. Oops, another surprise by the Indian Supreme Court. And then the last provocation, what is meant by public policy in Article Roman 5 2b of the New York Convention? I was once told, as a rule of thumb, Indian courts consider any violation of Indian law to amount to a violation of Indian public policy. I'm aware that there have been much finer distinctions, meanwhile, in the Indian Supreme Court in practice, but there is still this permanent threat, public policy that is much, much broader in India compared to other countries. So, I mean, in essence, I think the book by Datuk Professor Sundra Rajo is an extremely important tool to shed light on the Indian law and practice as to whether these are outdated perceptions, whether they are still kind of alive, lurking somewhere in the backstage, whether we can forget them, or whether case law, the legislator, etc., have to deal with these perceptions. Thank you very much for your patience. And again, I'm only the messenger, don't shoot the messenger.
Thank you, Stefan. In a book written from outside India, it was important to get perspectives of what it looks like from outside India. So thank you for your thoughts. You've sowed a lot of points for discussion for us, and I'd request each of the panelists to feel free to address some of these questions in the course of our discussion. May I request Gaurav to go next with his opening remarks?
Thanks, Som. Thank you very much. Let me start by saying that I agree with Darius, and I also agree with Professor Wilke. There is some of the remarks that were made about the intervention of Indian courts were correct, at least until maybe a decade ago. There is a marked change in the attitude of Indian courts towards interference in arbitrations, whether domestic or international. I think there would be rare exceptions when Indian courts would really go out of the way and intervene in a matter relating to arbitration. The general trend now, and I think I say 10 years, but I think at least in the last 5 or 6 years, sitting as a practitioner in Delhi, I have seen a marked change in the approach, both in the Supreme Court and at least in Delhi High Court and several other high courts. A hands-off approach to the extent it's possible, unless there is some really exceptional situation that demands intervention. In terms of ad hoc arbitrations, I think not adequate or not enough attention has been directed towards developing strong arbitral institutions. There are some institutions that are very successful and have a very good reputation, but there is still not a single institution that matches up to the reputation of, let's say, SIAC or ICC. But having said that, in the last set of amendments in the Indian Arbitration Act, I see that there is again a clear shift in the approach of the policymakers, and I think there is a clear shift in making a conscious attempt to encourage and then strengthen arbitral institutions. And so obviously it is something that did not get the attention that it deserved immediately after the 1996 Act was enacted. But I think there is already a conscious effort. It is slower than I would have expected in terms of progress in that direction. But I think there are good signs. The Hyderabad Arbitration Center, the Nani Palkiwala Arbitration Center, the MCIA, all have very good credibility. And increasingly, we already see the Supreme Court and various high courts giving them their due. I think from my own perspective, I think the process of evolution in terms of what is the role of courts, what is the role of arbitral institutions, I think is moving in the right direction. In some areas, it could have been faster than it should be. In some areas, it is already keeping pace with the change and the demands. But my own concern is something similar to what Darius said. I think there needs to be a greater focus now on the manner in which arbitrations are conducted in India. So I think there is need for greater attention and some more discourse about procedural innovation in arbitrations. We see there is need, for example, I think a change in arbitration culture and the quality of arbitration professionals, both lawyers and judges, who provide this service. When I say procedural innovation, I mean, for example, a country as big as India still does not have a single institute or an organization that provides real-time transcription for oral evidence, recording of oral evidence to match up with the standards of various commercial institutions sitting close by in Singapore. It is just because I think there is a little bit of inertia in terms of sort of shaking us ourselves and trying to bring up our sort of arbitration culture to the same level as it is internationally. And I agree with Darius. I think we need to focus much more on international best practices, more on written advocacy, less on oral advocacy, and tribunals should come prepared. We need not necessarily have tribunals of former judges, but having said that, some of our former judges are exceptional legal minds. Perhaps it would be a good idea for them to be exposed to much more of what is happening abroad. I mean, all of them pick up within the first 2 or 3 years, but perhaps I think it would be a good idea for example, the National Judicial Academy to provide some kind of training to those judges who are retiring in the next 1 year and would want to pursue a career in international arbitration or domestic arbitration, so that there is not a huge gap in the expectation that we have of professionals, both internationally and in domestic arbitration. That's my 2 bit, I think, on this topic.
Thank you, Gaurav. I think each of you have tabled points that we're going to go around in the discussion. May I request Chakrapani to give his opening remarks, and after that, Shravan.
Thank you so much, and greetings, everyone. It's an incredible honor for me to be a part of this very esteemed panel. Before anything, I would like to congratulate Datuk Professor Sundara Raju for his very inspiring book, and the very inspiring story that we just heard, what trials and tribulations he went through, and all that went behind making this book a reality. Congratulations, Professor. Coming to the topic of the day, and I must clarify, I'm not in rejoinder to Dr. Wilske, because some of the issues that he has raised are true. And that's something that we need to deal with. However, coming to the main point is, as Justice Sikri earlier mentioned, that many jurisdictions started their journey of arbitration laws by adopting ancestral model. However, in practice, when that legislation was put to test, each jurisdiction journey has been different. And that is only fair because each jurisdiction has its own nuance, its own reality, and so on. In my view, where things did not progress for first 15 years or so, but because of the lack of judicial tweaking of working of this convention in practice. And as a result, it was left for judiciary to step in terms of interpreting or filling in the lacuna. And that has its own limitations again, because any opportunity for judiciary to clarify a point must emanate from a case. So again, interpreting or defining law or filling in a lacuna, it will have to be viewed from the prism of the case that is before the court. And that is probably the reason why there were so many issues, so many conflicting judgments, which kind of gave uncertainty. However, all that is a matter of past. And after 2015 amendment, many of the things have been streamlined. And the way I look at it as a practitioner, that going forward, it's a long road. There are issues when it comes to execution of an award or even appointment of judges. There are still issues. And when interface of arbitral process with the judiciary happens, there is still that delay. However, all said and done, I think we are in a better place and it can only get better from here. Coming very quickly, Dr. Wilske, we do have exceptionally good lady judges or lady arbitrators, and they have rendered some fabulous awards. Also, in terms of retired judges, as Mr. Pachnanda was saying earlier, we have some exceptionally good judges who have served as very, very good arbitrators in some complex issues. And with little bit of training, I think all our judges can be very good arbitrators. Also, there is a growing trend, and this I say with my experience in last at least a decade, there has been a trend of appointing senior counsels and senior law firm partners as part of arbitral tribunal. And that experience has worked very well. So it's not just every arbitration or every ad hoc arbitration in India is run by a tribunal or a sole arbitrator who is a retired judge. Last point, and again, as I said, it's not a rejoinder, but I just wanted to share my thoughts that given the fact that India is a land of 1.3 billion people and it has its own nuances. So ad hoc arbitration is here to stay, it's not going. Because for certain situations, ad hoc arbitration is much better suited than an international arbitration, an institutional arbitration, pardon me. So given all that, it's something that is here to stay. It can be streamlined. Judiciary already has been very proactive in last several years, as earlier speakers have mentioned, and it has adopted this approach of least interference. I think we are on the right path. Thank you.
Thank you. Shravan, may I invite you now to give your opening remarks?
A very good evening to everybody here. And I just want to open by saying I'm hopelessly unmatched with the panel here, given the experience. But I just hope to make my contribution insofar as the institutional arbitration concept is concerned in India. I'm a practicing lawyer as well, and I've dealt with a lot of arbitrations and also some part of commercial mediations. I've had my share of training in both these aspects. The only trouble that I came across in being a counsel in arbitration was to was many a fold. One of the main reasons was some of the points that Mr. Stephen Wilske was mentioning in them. So I felt that there was an exceptional need for institutionalization of arbitration in India. But having said that, I do second the opinion of Mr. Chakrapani that India being such a large country, ad hoc is to stay for at least another 10 to 15 years. The only problem here is that we are talking about in the context of huge commercial arbitrations where the stakes are quite high. There is a need to regulate that particular arena where time is of the essence. So for that reason, institutions would really fare well in handling and administering arbitrations. And in that regard, I would say that institutionalization is the need of the hour. And I think Indian government has taken a proactive measure in bringing in such regulations, and especially through the 2019 Amendment Act to the Arbitration and Conciliation Act. However, I do have my reservations as an institution with respect to the amendments that have been instituted, especially with regards to the Part 1A that has been incorporated, with regards to the establishment of an arbitration council. And I per se do not have any trouble having some sort of a regulator at the center. The only trouble is with regard to the manner in which it's going to conduct its business is something that we all are yet to see, and how effective it is going to be, and who are the stakeholders for this body. And the only other part is the reason why I ventured into this arena of institutional arbitration, or per se the arbitration, was I'm a big fan of the word party autonomy. And I really love the word party autonomy because the parties are the bosses in which manner they want to conduct their arbitrations, and what would be the procedural laws, what would be the arbitration law, what would be the seat, and all so on and so forth. Now, by stating that there will be a regulation by the center in regards to the grading of arbitral institutions, especially Section 43K, if I recollect this correctly, which prescribes qualifications of an arbitrator. I mean, the Initial Arbitration Act speaks about who can be an arbitrator. Anybody can be an arbitrator. But now there are certain regulations, certain provisions of law which prescribe the qualifications of who can be an arbitrator. So the party autonomy is something that is being transgressed into by this so-called governing body, or rather a regulator. And also the grading of institutions that will happen across the country is something that they will be taking up as we have a proper the Arbitration Council of India doesn't seem to really have the infrastructure as of now to do all of the tasks that have been entrusted to it under the Part 1A of the Amendment Act. But grading of arbitral institutions seems to be one of the most primary things that the council would be taking care. And it doesn't say as to what are the criterion on what basis would the institutions be graded, and how it would affect the ongoing arbitrations that the institution is administering at that point of time. I mean, what conduct of an arbitral institution would result in losing the recognition, and what would be the fate of the arbitrations that are being administered as on that particular date, and so on and so forth. I do have my own reservations on Part 1A, but the Supreme Court of India, I think, has been doing tremendous, has been giving tremendous support to the arbitration community in giving out proactive judgments, and the rest of the panel has already covered as to the manner in which we are progressing towards a pro-arbitration country. And one has to see in terms of the institution and also in terms of being a center which could administer international commercial arbitrations in the future. I think a seat-centric mindset that prevails right now across the globe, I think, has to change. And once this kind of progressive steps that is taken by the Indian judiciary would probably lessen the doubts that have been expressed by Dr. Stephen on an international front. People would probably be preferring to have the seat of their international arbitrations per se in India. But I think there's a lot of, that's a long way to go. I do realize that, but having said that, I do believe that it is possible in the near future. And that's all my two bit on this topic. Thank you.
Okay, thank you. I'm going to push the panel a little more on this facet of institutional arbitration. What is holding back the emergence of institutional edifices that will give us what we miss? What is the cause? Is this a market failure? Is it the absence of insurance which drives investment in, for example, the transcription software, as Gaurav mentioned? Whereas you mentioned that the software is ready, the hardware needs a rejig. So I'm going to push you all back a bit, and can we very crisply talk about what is missing and what needs to be done?
Can I kick off? Can I kick off? I commend Dr. Wilske for his 9 points. I think many of them are hard hitting and true. There are two or three of them that are outdated. So no Indian courts don't interfere in foreign seated arbitrations or awards any longer. No Indian courts don't equate every transgression of law as a violation of Indian public policy. But yes, there is a lot of intervention by courts at early stages, and I think that's primarily because we don't have institutional arbitration in a big way. I think that's the bane of Indian arbitration. And Tom, to answer your question, it's very simple. You can only have institutional arbitration if the two parties agree to it. It's got to get into that arbitration clause. It's hopeless to think that after disputes have arisen, anyone's going to agree to an institution. And I think the time has come for the big Indian law firms to take a kind of pledge that they will encourage all their clients to go for institutional arbitration. I don't believe that institutional arbitration is more expensive. That's a common fallacy. I actually think in the long run it's cheaper. Or just as I think in the long run having real-time transcription is cheaper, because people only look at the absolute cost per day, but they don't look at the fact that real-time transcription gives you two tremendous advantages. It cuts short the time of the proceedings by at least 50%, if not more, and it provides you an unimpeachable record of what happened. And by cutting short that time, you save on the costs of the tribunal, you save on lawyers' costs, you save on a whole heap of things. So these are fallacies that afflict our arbitration. These are the hardware problems I was speaking about. Retired judges as arbitrators, there is a lot of confidence in litigants in India in having retired judges, but it's not without exception in the sense that there are courts. I know the Bombay High Court, there are some judges who insist on appointing counsel, and especially junior counsel, to do quick arbitrations and finish them in 3 months and 6 months and things like that. Diversity, well, isn't that the old problem? Because I remember years ago, speaking at a seminar about 7-8 years ago, and someone said the problem with international arbitration was all the arbitrators are pale, male, and stale. And at a certain level, there is that problem in India as well. Yes, I would welcome very competent lady judges and counsel, and that has to be encouraged. Again, institutions can encourage that. Ad hocism cannot. Finally, I just want to I share completely Shravan's apprehension about the Arbitration Council of India. I think it's a huge mistake. I have to say it openly and very categorically. I've said it before. We cannot have a regulator in the field of arbitration. That would be a huge, huge mistake. And there's every danger that such a council will slip into the role of a regulator. So yes, there are problems ahead, but I think the systems are gearing up to address those problems openly in a transparent manner, and hopefully we'll find solutions to all those.
Okay, so I may move on to the next point I really wanted to talk about. Can we talk a bit about? Yeah.
Sorry, may I come in here?
Yeah.
About very quickly about this why institutional arbitration has not taken off here. It's a bit of a chicken and egg, and what Mr. Khambata just mentioned, that it needs to be put in those agreements. Now, as we speak, the ground reality is that it is happening now. However, corporates are veering towards putting those clauses. However, to take that off, it will take a couple of years, and it also requires huge amount of awareness that needs to be created. Because unless we create this awareness and parties sign in and actually put this in their arbitration clause, in their agreement, it's not going to take off really. So I just wanted to add that bit.
Right.
Just
Okay,
to
I was more on
that, if I can just add another supplement to that.
Shravan, if I may just table a point for you, you may want to address that as well.
Sure.
Typically, markets are meant to work. And if the market worked well, the institutions would have emerged and parties would have accepted institutional arbitration more willingly. That's how demand and supply interface happens. And if that doesn't work, regulators tend to step in and say there's a market failure. Now we will develop the market. If you look at regulators across sectors in India, they have a twin-fold objective: orderly development of the market and regulation of the market. So if, and Arise is warning us against that kind of approach in the field of arbitration. So you may want to focus some of your points on what is leading to this market failure.
Well, to precisely just answer that question, there's one word. That's there's no proper education or training towards the benefits that can be taken to the stakeholders, that is the parties to the arbitration, as well as the practitioners. And precisely just to continue what Mr. Chakrapani said, I wanted to supplement it by saying, yes, what he said is making sense. And the other one, that we as institutions are now compelled to also take up the roles of educators. And I think, AIADR is a fine example for that, right? So they are actually coming up with training modules to educate retired judges, or people from various backgrounds, not only from the legal background, but from engineering background or medical field or the business field. So the need to educate that there is a facility that can be utilized for the purpose of such and such is not there. So the awareness is a single word answer that we as an institution have faced, and that we as an institution are trying to overcome. And moreover, no institution can administer an arbitration without having its genesis in the agreement between the parties, the arbitration agreement, unless and until the parties state that in the event of a dispute that arises between us, we shall get the same resolved by arbitration administered by Hyderabad Arbitration Center or SIAC or ICC Court of Arbitration, whatnot. The genesis lies there in the arbitration agreement. Now, as an institute, we have been trying to create awareness that the facility is available and in the circle that we could reach out to through our propagation, through these sort of learning initiatives or symposiums, trying to instill this particular practice of having an arbitration clause that names an institution. Otherwise, it becomes much more difficult at the later stage to name an institute in the arbitration agreement. But that seems to take really long time. And as you said rightly, I think the regulators seems to have stepped in right now in the form of the Arbitration Council of India. But all that the Arbitration Council of India ought to have done is stick to the report that was submitted by an expert committee in 2017 regarding institutionalization of arbitration. In addition to what probably that they have picked up from the report, Justice Ravindran, Justice Ravindran headed that report, if I'm not wrong, please correct me. And that recommendations ought to have been installed. And in addition to that, they should have supplemented it with effective clauses, not in this manner of putting certain restrictions on who can be an arbitrator and saying that we want to regulate even the institutions. Now, institutions are, regulation could bring to a certain extent some benefits, but the regulator saying we will institute any arbitration in India has to be institutional is something that really goes to the root of the problem. Even as an institution, I say this because parties should have agreed that they want to go for an institutional arbitration. They should have a choice if they want any of their family members to be the arbitrator, or a third party, or their friend, or a professional arbitrator from abroad. So the party autonomy should not be touched upon is what I believe.
That's it. So I have two other points I want to table for the
Tom, before you go that, and I'll very briefly, I wanted to add a very small point because I have a slightly different perspective on this institutional arbitration, and I'll try to be as brief as possible. In my experience, I think one of the biggest problems that we have in arbitration in India is the fact that that in reality, government is one of the biggest litigants, whether in courts or in arbitrations. It is either the government or government-owned corporations. And there is a very high degree of suspicion towards private individuals. Now, that is the, I mean, we can go into the reasons for that, and I wouldn't be able to articulate all the reasons. But in my experience, I sense a very strong degree of suspicion of private individuals, which has, of course, led to only former judges being appointed, because I think there is greater acceptability of former judges as far as government-owned corporations and government are concerned. And also, the shift towards arbitral institutions has been slightly difficult, because those institutions that have come up and are doing very well are largely private institutions. And as I see, perhaps the concept of this arbitration council was an attempt to give some degree of credibility to graded arbitral institutions. While I disagree that it might end up giving that kind of credibility, it might actually become an impediment. But I think the source of the problem tends to be this suspicion towards private individuals and purely private arbitrations in an arbitration paradigm where the government or government-owned corporations are one of the biggest litigants. Sorry, you were saying something and I interrupted you.
No, I think that's perfectly fine, Gaurav. I was just trying to move on to the next topic. I have one eye on the clock. We still have 21 minutes. So I'm going to table 3 points and leave it to the panel on which of these and how you want to address it. And I'm following Datuk Raju's construct of an issue-based discussion. So one point I want to table is the thing about arbitrability. And he's devoted a chapter literally on that subject. How do we compare with other jurisdictions? And Stefan, I'd like you also to come in from the perspective of how it looks from the outside. Is there a purposive reading to be given to contemporaneous contracts and the conflict between contemporaneous contracts on privity to the arbitration? That seems to be one of the core issues that comes up in commercial transactions. Number 2, fraud, arbitrability in the context of fraud. And number 3, arbitrability in the context of IPR disputes. This is one point I want to table. And the other facet, which I liked from the book for a discussion like this, was the whole debate about the adversarial approach versus the inquisitorial approach. How do we compare with the world? Is there some reform that's due there? Is there something we could do on that? My final point is on enforceability. That's the juicy part, but we'll come to that last. So on arbitrability, if there are comments that any of you want to make on the 3 facets in particular.
Yeah, let me take the first shot because I am slightly dissatisfied with the state of Indian law on arbitrability. I think, for example, there is a lot of positive development on arbitrability of matters relating to fraud. There is much better jurisprudence than there was, let's say, a decade ago. But there are several aspects in which I think there is a problem in sort of deferring commercial disputes or civil disputes to arbitration. And there is a greater tendency to sort of keep them away from arbitration. And I'll give you an example. For example, it is fairly normal in actions relating to oppression and mismanagement of a minor shareholder for the nature of the dispute to essentially be a shareholder dispute, and yet one party would invoke a statutory remedy towards sometimes often, I mean, to prevent the arbitration from taking off, but quite often in the midst of an arbitration, sometimes even when the award is just about to be pronounced. And I think the tests that Indian courts have evolved, for example, of a dressed up action or similar concepts, I do not believe that those are very well-defined tests, and they are very subjective and will vary depending on case to case. And I think the fact that until clarification by the Supreme Court in Vidya Durolia, for some time, even landlord-tenant disputes were perceived to be non-arbitrable, is an indicator of where the state of law is on arbitrability. when it comes to IPR disputes, I think when you look at the Supreme Court's decision in Buzalin and you just follow the first principles that have been laid down there, I think IPR disputes are much more evolved in the sense that there is there's greater clarity that while the right to ownership to an intellectual property might be a statutory right and may not necessarily be arbitrable against the authority that registers your ownership, but subordinate rights where you have disputes regarding subcontracts based upon a pre-existing ownership, there is greater clarity on those aspects. But when I look at the overall state of affairs on arbitrability, I think it's on some areas there has been good attention and the law is clarified, but on some areas there is inadequate attention paid. And I think the law still is a bit mixed up. And I think the fundamental problem in all issues relating to arbitrability is that we have this judgment of the Supreme Court in Sukanya Holdings, which somehow has been interpreted in a manner to say that if a part of the dispute is clearly arbitrable, but the other part of the dispute is not arbitrable, then you don't have to send it to arbitration. And I think that is the basic principle that needs greater clarifications, a clarification by the Supreme Court, because I see no reason why arbitrable disputes cannot be split and sent to arbitration, and non-arbitrable parts of the disputes cannot be decided by appropriate forums, as they are in several other jurisdictions, including the United States and I'm sure in Europe.
Right. Stefan, would you like to add something on this from the international perspective on part of the cause of action being arbitrable and part not?
Well, I was only shivering when you mentioned fraud. My experience is that whenever your opponent is out of arguments with kind of twisting the wording of a contractual stipulation, the argument of last resort is always, I mean, this agreement was procured by corruption or by fraud. I see this so often, in particular in an investment arbitration context. And I'm a little bit afraid. I mean, if someone screams corruption, fraud, and then you're out of arbitration and to the state courts, that's a bit too easy. That's my only concern. I mean, I'm taking corruption, fraud very seriously, but it may not serve as an excuse, as an argument of last resort to commence the whole proceedings once more at the state court level.
I think I think the time has come also for perhaps, and we look forward to a judgment of this nature, to have a very broad brush approach rather than get granular what can go to arbitration and what can't go. I think every civil dispute should be arbitrable, regardless of what field of law. The only exceptions can be two, to my mind, in rem areas, which are always traditionally non-arbitrable, because you affect the whole world with that determination. So there's no question of two parties going off and doing it on themselves, by themselves. And where a statute specifically excludes the jurisdiction, all other civil jurisdiction, and vests that jurisdiction only in a special tribunal or court. And we shouldn't get too expansive about this. I know that in some judgments, the Supreme Court has even said that where an act is a complete code, disputes under that act should not be arbitrable. I think that's going too far. Is there a clause in the statute that excludes the jurisdiction of civil courts? If there is, that's it. No implied exclusions. And just about everything else should go to arbitration. And I think that's quite easy. IPR was mentioned. Obviously, if you have a dispute about who should be on the register or whether the register should be rectified, that can't go to arbitration. But every other dispute, infringement, otherwise, these are really essentially in personam disputes. There's no reason why they shouldn't go to arbitration. Fraud, I agree with Stefan. It's the most misused plea, not only to avoid arbitration, but in our courts. The word fraud is bandied about so easily. And I don't even think most of us know what we mean when we say fraud. I think, yes, every kind of civil fraud should go to arbitration. There shouldn't be a problem. What's wrong? I mean, arbitrators decide very complex matters and issues. Why can't they decide questions of fraud? So as long as there's no criminal decision, there's always a criminal connotation, but that's the subject matter of independent criminal proceedings in any case. So I don't think we should get into this granular type of scrutiny.
Right. May I nudge you to the next point about enforceability, the second innings at enforcement? And what are the trends? Do we have any empirical data to pick any trends on how things have moved in the space of enforceability of arbitration awards? What is the judicial attitude? Is it actually shifting, or are there wide perceptions like the six blind men and the elephant in terms of which way this is headed?
If I may take a shot very quickly again, a quick answer to what you're saying is courts are much more conscious now of enforceability. Awards do get enforced, but it's still taking far too long. I think that's the problem. Ultimately, you get enforceability, but the time lag is something that a system should not be able to tolerate. It's just taking too long.
So in my view, I think the problem with enforceability of civil judgments generally in India is a huge dragon in itself. It takes perhaps as long or even much longer to enforce a civil judgment in India than it takes to get a judgment. And I think the problem is, in my view, the problem is that once you have an award and you put it in the system for enforcement, the courts are bound to follow the code of civil procedure for the purpose of enforcing the award. And I'm thinking aloud here, but I have for the last few years been of the view that while there is substantial progress in terms of enforcement of awards, I think it would be a better idea to not really follow the rigors of enforcement of a judgment of a court for the purpose of enforcement of an award. And you saw that in the Amazon judgment in the Supreme Court. For the purpose of enforcement of an emergency award, the court was willing to regard it as an order under 17(1), but not willing to accept that it would be appealable. Any order passed for the purpose of enforcement would be appealable in the same manner under Order 43 or under 43 of the CPC as it would have been if the order had been passed for the purpose of enforcement of a court order. And I don't have a definitive answer, but I do believe that there needs to be a more summary procedure for the purpose of enforcement of awards, and should not be subjected to everything that you have in Order 21 of the CPC.
Yeah, I kind of agree with that, because that's the problem. That it's like once there is an award, it sits in the same chamber as a decree of the court. The court system is already too clogged. Now, in an already clogged system, we put in this award also for execution. It's a recipe for nightmare, and that's where it and then it's a whole process of challenging and all sorts of things that go with it. So I agree with that suggestion that probably if Arbitration Act is a code in itself, probably it should be a more holistic code where it also provides for summary execution. Barring some just exceptions, maybe in some complex cases, it may resort to assistance of court, etc. So again, distinguishing that, maybe assistance of court machinery, maybe, but the process itself should be independent. Probably that would be the solution to it. Otherwise, I don't see anything happening here, because courts are very, as rightly said by Mr. Khambata, courts are very conscious of that award needs to be, especially coming from a reciprocating territory, it needs to be enforced. So there is no difficulty on judicial thinking. Is the process, is the machinery that is already overworked. So probably unless we separate it, it's not going to change. That's my view.
Great, thanks. Shravan, do you want to comment quickly on this? I want to also highlight, if you can talk about domestic awards and enforcement within India.
Yes, I mean, I can't add anything more. It has been extensively covered by the senior counsels as well as Mr. Chakraparni. The only thing that I faced as a practicing, as an arbitration practitioner, while I went for the enforcement of an award before a district judge, the question that was posed to me was who filed this case and how is this enforceable? Seems to be passed in a completely different jurisdiction, and all of those questions that come up, and you tend to explain the judge, and with all your efforts and might trying to convince him the other way, but he says, can you please provide me a copy of the Arbitration and Conciliation Act so that I can read it tonight and then I come back tomorrow so that we can hear. So that only shows that there is also an absolute need to train judicial officers in the subject of arbitration and the enforceability, how and also Section 9 applications or the 34 applications. So I see that there is a huge vacuum there. I think something has to be done, and the absolute need is to train the judicial officers. And I've faced it not once, twice, especially in the state that I come from, in the lower districts. The district judge is absolutely oblivious of what provisions are there in Part 2, at least, of the Arbitration and Conciliation Act. I think that also is the need of the hour to make sure timely, steps are taken.
We have exactly 7 minutes to go. So I'm going to go around the table for each of you to, if you want to see one legislative change that may nudge reform or movement in this space, and if any point made by an earlier speaker is something you confirm to come up with another point. Let me go around the table with 1 point per person. What is the change you'd like to see in the law governing arbitration? We could go in the same order. Dharaj, Stefan, Gaurav, Chakrapani, and Shravan.
As I said, actually, I think much of the software or legislation is already in place. It's the implementation of it that's the problem. But since you're putting a legislative intervention in place, I think it's imperative that we clarify that investment treaty awards are commercial for the purpose of enforcement of under the New York Convention, because we've recently had judgments which suggest that they are not commercial and therefore are not enforceable. And since India is not a party to ICSID, I don't know how anyone can then enforce an investment treaty award. It's a little alarming, because then what's the purpose of having arbitration clauses in investment treaties? So I think for legislative intervention, I'd go for that one.
Right. Stefan?
Well, I concur with Darius Kambata. I mean, that's absolutely necessary. But I take the opportunity to say that I'm very happy that I was wrong with one perception, namely that there are famous lady arbitrators in India. And next time I will receive a short list with 3 male arbitrator candidates. I will insist of having one of these lady arbitrators on the list as well. Thank you.
You got it.
In terms of legislation, I mean, I can't think of anything more than what Darius has said. But I think at the level of intervention at a policy level by the government, I think that there is great scope and appetite for a government-supported international arbitration center to match up with endeavors in the region. I mean, a lot of our top-end commercial work is now in SIAC, and it is there because they do very good work. The standard of services are very high. But a lot of us, but you see that this work is now outbound. It is going away because the service is not available. That quality of service in terms of an arbitral institution in big high-end disputes is not available. And I say, and I think government intervention is required because predominantly a lot of those disputes would involve government or its arm, and any arbitration center or an institution would have to be acceptable to the government for it to take off in India.
Chakrapani?
2 things, or maybe one. If it is one, then I would go with my reforms for execution, that a specific provision should be made for execution of awards. If more, then probably little more clarity on multi-party arbitrations and multi-layered arbitrations. Probably some legislative change there or clarity there would be of great help, because commerce is getting more and more complex. And probably our act may be benefited by some change on that side. Thank you.
Shravan?
Yes, I think I'd be too naive to say, but I think third-party funding needs some sort of legislation in India as well. There have been some interested parties or funds that have been looking towards arbitrations that have been administered by SIAC and ICC Court of Arbitration, where there was a need. But the vacuum, the confusion, or rather, I would say the lack of legislation or a regulation for that matter, is something that probably would turn heads towards India, that even we are progressing towards that. But I think very little number of countries have done that. And also I second Chakrapani and on the execution part of it. I think there is an absolute need to come up with some sort of legislation on that. Yes.
Thank you. There's so much to talk about and so little time. So I'm afraid we'll have to draw a line here. Thank you, each of you, for such wonderful insights. I'm sorry we really run out of time. There's so much more. I'm very, very tempted to ask you and keep this conversation going. And thank you to Irene and team. I can see Justice Sikri's again on my screen. Thank you, sir, for setting the tone. Thank you, Datuk Raju, for taking the effort to write such a lovely book. To all the friends in Malaysia, may I end by saying, Terima kasih, Setse, and Mikka Nandri. Thank you.
Thank you, Mr. Somasekar, and to all our wonderful speakers.
Thank you, everyone.
We trust you have been impacted and with the insightful session. Right now, we would like to proceed to our networking session. Thank you all for coming to the webinar. If you pay attention to the link, there will be a link to a separate Zoom link. So what's going to happen is, since time is getting a little bit late wherever you are, we will run the networking session for about 20 minutes. All right. So if you are keen, you just hop on over to the Zoom meeting. We'll be more than happy to host you and to see you over the other side. Thank you everyone for joining again this evening. Have a wonderful evening and have a great weekend.
Thank you very much. Thanks.
Thank you.
Thank you.
Thank you so much.